Arnold, before the short adjournment, I promised to give you the references in the Peter Pan case. It's at authorities 1 tab 11. The head note is actually quite clear on the point. On the bottom of 110. So here is the claimant, or the plaintiff, Peter Pan, had given to the defendant complete patterns and all information regarding the manufacturing service style. They subsequently showed a sample of the new design. All that information was given in confidence, and you can see the full detail of it from page 112, just below the second hole punch.
Starting towards the end of 1951?
Starting, yes. Yes. So they start off by showing them the brassiere of the so-called hidden treasure style. This was the cup-to-cup method of construction, which was the subject of the confidence. Silhouette, not at that time acquainted with that method, shown in confidence, were pleased with it, accepted the license, and then they sent full particulars concerning the manufacture of Peter Pan brassieres, complete layout plan, specification, books of samples, patterns, complete set of brassieres, the whole shooting match, as they say. He notes the process of manufacture didn't include any device which wasn't known to a case of ascertainment, but it would take the manufacturer starting from scratch up to 6 months to make a copy. There's a supply and confidence.
Sorry, where are you reading from, Mr. Purvis?
I'm sorry, this is the bottom of 112. I was just reading on from the bottom of 112. That paragraph starting on November the 12th, 1951.
So they got a complete guide.
Yeah. And again at the bottom of 114, just below the second hole, starting silhouette admitted. Up to 3 lines. Peter Pan supplied silhouette with a stream of information, raw material times, they had the templates, other patterns, cutting them out, etc. And it goes on, but essentially I think the pithy headnote pretty much summarises that this was a case where the entirety of information needed to make the product had been handed over in confidence. And therefore it was right to say, rather unusually, that the subject matter of the cause of action was entirely derived from confidential information. Rather like Miss Justice Slade's parasitical enterprise, feeding itself entirely off the plaintiff's goodwill, although in this case, off the plaintiff's confidential information. So those are the cases where the courts have, on odd occasions, made an award of an account of profits comprising the entire profits on all the articles which were held to be breach of an intellectual property right. Turning now to types of apportionment that have been carried out in the authorities. It is quite apparent from the authorities there's no one-size-fits-all approach here. A multiplicity of different approaches have been taken in different cases depending on the particular facts. one can divide them perhaps, first of all, into cases where individual customers can be identified for whom the underlying intellectual property was the very essence of the product they wanted, was the critical element in the purchase of the product, and therefore it could fairly be said that the profits derived in respect of that customer ought to be payable, but other customers not. That doesn't apply in every case, but it was the case we would submit in My Kind of Town, where Miss Justice Slade, as we've seen, says that you could hand over the profits in respect of the people who were confused, but not the people who weren't. And that's a type of apportionment, in a way. One takes the overall profits and one sees what's attributed to individual customers for whom the invention of the product was critical, in the sense that it represented the entirety of what they wanted. And one can see the same thing going on at a rather more sophisticated level in Abbott, because as you'll recall, there were two types of apportionment going on there. First of all, the judge was directed to find those customers for whom the design of the insert itself drove the sale of the panels. And in respect of those customers, the whole profits could be awarded. But then there were the customers for whom that couldn't be said, turned out to be the vast majority. If we've got Abbott, JA2, tab 47. Turn to paragraph 30. 37.
Yeah.
Yes. So, well, it probably starts a little earlier. Maybe at 34. We could probably start with Mr. Cuddigan's submission. It said that this argument at the end of 34 was not permissible. That's the argument for apportionment because of the way the issue was framed. The issue was framed as follows: are the claimants entitled to claim the profits which accrued to the defendant as a result of slatted panels sold together with the clipped and aluminium extrusion? He argued this was a binary question. The judge had to answer like yes or no. I don't agree it was open to the judge to answer the question by holding that such profits could be recovered in some circumstances, but not in others. And my lord then goes on to revert to the example of the car with the patented brakes that was given by the full court in Dart Industries. From about 6 lines down, so the legal error the judge made, that's judge below in this case, was to ask whether the sale of the panel plus insert would have happened separately, rather than have to ask himself how much of the profit was derived from the infringement. In the case in which the infringement doesn't drive the sale, it seems to me it's wrong in principle to attribute the whole of the profit to the infringement. In particular, it doesn't follow. In fact, the customer wanted to slap wall and incorporate an insert that they wanted to slap wall and incorporate the infringement. Cuddigan argued that the inserts of the slot with the very essence of the incorporated and unincorporated panels. The judge made no such finding. His observations suggest the contrary. I don't consider the judge was correct in saying in 31 that because the sales went together, that is the inserts and the panels, the sale of inserts caused the sale of the panels. The mere fact the two went together is not sufficient to establish that there was a profit growth from invention. Might as well say the sale of the panels was the sale of the insert. As the judge recognised, customers specialised panels on the hypothesis he was considering at 31, and that's quoted by your lordship at, in fact, at 30 of your judgment, a page earlier. That's being the customer, whether the customer's indifferent to the type of inserts.
Yes.
On the judge's approach, because the sale of the patent of brake and the sale of the car, the whole of the profit would be included. If the judge had found on the facts that the infringing insert was the essential ingredient in the creation of the defendant's whole product, then it would have been justified in the decline's proportion of profit. But it didn't find. So that in 37 you conclude in cases simply falling within the factual hypothesis. In 31 the judge should have apportioned, and the question of apportionment will therefore have to be returned to IFAC, though the judge wouldn't be precluded from finding the fact that the infringing insert was the essential ingredient of the incorporated panel. And what the judge did was separate out, so found that for some it was, I think, quite a small number, but generally not, and therefore apportioned in respect of those sales. So that's a slightly more sophisticated version of the My Kind of Town, simply separating sheep from the goats in terms of customers.
I mean, in My Kind of Town, the criterion was whether customers were confused or not.
Essentially, yes.
I mean, you can well imagine a customer being confused, but saying, well, the reason I went to this particular restaurant is it's the closest to my house.
That's a very good point, which the judge doesn't make, I think, in My Kind of Town. I think the assumption is if the customer was confused, that's why he'd gone to the restaurant. Yeah. It might be said, you could go to the restaurant anyway and then be confused whilst you were in there, for example. But anyway, that wasn't addressed. It's rough and ready, as they say. So what of cases like the present, where we're concerned with complex products, where the IP right is just one amongst many significant aspects of the product? There, a number of methodologies have been used to balance the value of the substance of the IP right against other causes of the success of the business that led to the profits. Now, this is sometimes referred to as an aspect of legal causation, and we would submit that that is a reasonable characterization, but in none of the authorities dealing with accounts of profits, at least before this one, has any judge attempted to do a strict factual causation, legal causation analysis and divide the various aspects of what he's considering between those two different elements. But it's true to say that the approach here in terms of apportionment is different to the normal approach in a tortious damages case, where the question of legal causation of a particular head of loss tends to be binary. Was it caused or not? Can it be recovered or not? Interestingly, as we've noted in our skeleton, the idea of apportionment does accord in some ways with the approach taken in patent damages cases, where if you can't show lost sales damages, you recover as a patentee generally damages on the user principle. in which an element of sharing of profits between, or potential profits, we'll come back to the detail on that, between patentee and infringer is carried out. That actually is what happened in NEO, where the lost sales to Rhodia of cerium oxide for the catalytic converters being supplied by JM to the car companies were held factually to have been caused by the original infringement, that is to say, obtaining the approval by having them tested in the United Kingdom. But in fact, they were held not to be recoverable as a matter of legal causation. We'll come to that case later, but by reason of the multiplicity of other causes of those sales. But that didn't mean that Rhodia recovered nothing, as it happens, because they were awarded reasonable royalty, as far as I can see on the face of the judgment, in respect of those sales. My friend says they weren't, but certainly that appears to be the case. But we'll have a look at it later when we come to propositions in there. It probably doesn't matter a great deal for present purposes. Looking at the various analytical methods of attributing the relevant proportions of the profit between patentee and infringer, there are probably 4 different types, ways of doing that, which we have identified as having been used in the authorities. The first is the so-called cost-based analysis, which is an accounting technique based on the, as it suggests, the associated costs of production of the relevant components using the invention and not, or using the intellectual property rights or not. That accounting technique seems to have been used in Celanese and in Potton. Obviously, it gives some picture of the significance of a part of a process or product by reference to some objective criteria, but it has quite a lot not to recommend it, because, as Justice Laddie held in Celanese, what it doesn't do is reflect the value of the individual element to the user or to the prospective purchaser. And he recommended, therefore, that it would require some degree of weighting, that's WEI, weighting, depending on the impact on profitability, for example, of the different cost elements. The second approach is something similar and perhaps more useful, using a sales revenue based analysis. That actually is what His Honour Judge Haken did in Abbott when it returned to the court in relation to the combination panel and insert sales. For your reference, I don't think we need to turn it up, that's bundle 2, tab 50 at paragraph 51. Of course, to be able to do that, you need a clear distinction between the infringing and non-infringing elements and existence of separate selling prices for the individual elements, which they happen to have in Abbott. So it is a relative rarity, I would suggest. But that's how he did it. The third way is looking at contemporary evidence of the value attributed to the invention as a proportion of the business by the parties themselves, e.g. in a license agreement. So this would be, in particular, the value attributed to the invention by the claimant, and applying that to the profits as representing what the parties, as those who should know best, thought was the value of the invention compared with the product as a whole. That we submit is what was done by Mr. Justice Briggs in Cipriani in combination with a distribution of costs approach, because he was also looking at the distribution of costs for business. And it was also done in Jack Will's, tab 48, paragraph 61 to 64. I'll come back to the submissions that have been made about those two authorities when I deal with round 4, if I may. But we submit that that is an established methodology. And the fourth approach is one which has been talked about in the authorities but not used, which is what's sometimes called differential profits, or the approach based on the closest non-infringing alternative. Now, as we've seen, that method has not been adopted in the UK courts to date, in part because it was regarded as not open to the courts because of the decision of the House of Lords in the damages case, or United Horseshoe and Nail, and that was held by Mr. Justice Laddie in Celanese and followed by Lord Justice Jacob, I think, in Gerber. Now, before you, both parties before you agreed below that there was in fact no basis for a legal bar to considering a differential profits approach in an accounts of profits case. United Horseshoe is, of course, a lost sales damages case, and we would submit binding on the court in respect of lost sales damages in an infringement of patent case, but not otherwise. We would submit it is another potentially useful tool which the courts can use as a method of apportionment if it works on the facts. And that's quite a big if. The theory is obviously simple. If one imagines a straightforward case where there is a history of a product or process being made and sold without the improvement, which is the subject of the patent, and the improvement is then introduced, one can look at the profits of the one and the profits of the other, and by a process of subtraction arrive at the profits due to the invention. Perhaps simplest in the kind of case that Mr. Justice Laddie was talking about, a process patent where an invention saves some money so far as the user is concerned. Well, there's an existing process. The invention enables the process to be carried out at a lower temperature, therefore saving some production costs. It may be a relatively straightforward exercise to compare the saved production costs with the previous costs and say, well, the profits have increased accordingly by that amount of money. Of course, it doesn't necessarily follow. You might choose to use the saving to cut your sales price. I'll have to look to see if that has actually improved your profits or not. But in principle, one can see how the proposition can work. And it's quite an elegant theory in principle, which has attracted academics. And you will have read Mr. Cuddigan's reply skeleton, which quotes some of those academics at length, explaining why it's extremely useful. And we would say, in theory and in the perfect case, there's no doubt that it can be or could be. We would also say that the academic writers are perhaps a little prone to massage away the real world issues, which can make this approach suboptimal. Just to fill that out, a number of points spring to mind. The first is, unless you have a record of an actual product being made and sold before the introduction of the invention, the exercise is inherently hypothetical. You're essentially imagining the production of a product without the use of the invention, which might be hard to assess in terms of profitability. Since not only do you have to imagine the product, you've got to imagine a price point, likely demand, likely response of competitors, etc. Not necessarily straightforward. Secondly, you have to decide as a matter of law what restrictions on such a hypothetical the court will insist on. In particular, does the hypothetical product have to be one which the defendant could practically have made that had acceptability to customers? This was what divided the Supreme Court in Over and Down in Canada. What if it infringes someone else's right? What evidence is required to show what the product might have been, and on whom does the burden lie? Is it permissible to rely on the fact you could have bought the patented element from the patentee or a licensee if such elements were freely available? Does it matter that the NIA couldn't in fact have been put on the market for reasons unconnected with the invention? Does it have to be a consumer alternative to the invention? That's to say, a ready replacement for customers, or simply a different product line to which the defendants would otherwise have diverted their manufacturing resources. All those things would have to be worked out in case after case, and one can see in Canada that they have, because they have been using this technique for a few years, some of these issues have been examined. The point that arises in this case, or arose in this case, also throws some doubt, we would say, on the universal utility of NIAs. How do you deal with the situation where it's not clear whether a supposed NIA itself infringes? We've got precisely that in the present case, where the poor judge below had to deal with essentially a patent infringement case to establish whether the product that was being put forward as the alternative fell within the claim or not. And one could envisage situations, as we've said in the skeleton, where one ended up with a defendant putting forward a cascade of different potential non-infringing alternatives, getting further and further away from the invention, and running them all as fallbacks, and having to have evidence in relation to each of them on the likely profitability, and that is procedurally unattractive as well.
Well, I think Mr. Cuddigan's riposte to that is that the infringer would have to show by evidence what it would have done.
Yes.
And it may not be plausible for the infringer to say, well, I would have made product A, but if I'd known that that one infringed, then I would have made product B, but if I'd known that that one would have infringed, then I would have made product C, and so on down your cascade. It'd be rather improbable evidence for somebody to give, wouldn't it?
That's one possible way of looking at it. We would suggest actually that isn't what non-infringing alternatives really represent, when they are essentially hypothetical, and therefore by definition one's not looking at evidence of fact from the defendants about what they actually had in the pipeline. One's looking at hypothetical products to try and get at the ultimate question: how much is the invention worth?
Do I understand that to amount to a submission? The question is not a subjective one as to what was thought to be the NIA, but an objective question as to what was in fact. So, well, fact is the wrong word, but on an objective analysis, what was actually the nearest available NIA.
Yes, and a good example of that can be seen in Nova and Dow itself. I think in a passage which you looked at. Is that 90? Yes. Yes. So one goes to paragraph 51. Well, I'll start at 51 on 3003. So first of all, this makes clear that the purpose of looking at non-infringing options is to help the court isolate the profits causally attributable to the invention. And if you jump to 53, you can see non-infringing options can also help courts determine when some but not all of the profits causally attributable. They give an example of the case of Rivet and the related judgment in Monsanto and Janssen's. Defendants infringed Monsanto's patents by, federal court required them to disgorge a portion of their soybean profits. Some of them were causally attributed, infringed them by planting genetically modified soybeans without license. The defendants profited by spraying the crop with herbicide, increasing harvesting yields. But if you look over at paragraph 64, you'll see what's said about Rivet, where the learned judge says the facts are instructive. Mr. Rivet was unable to establish that he could have planted regular soybean seeds because they were not available for purchase in his locale. Rivet at 63. I'm sure whether locale is a technical word there, but anyway, he couldn't buy them. Despite this unavailability, under the reading of Schmeiser, it was appropriate to consider regular soybean seeds as a relevant non-infringing option. Considering what profits he would have earned with those seeds allowed the courts to isolate a portion of the profit causally attributable to the invention. So even though he couldn't actually have done it without infringing, as a matter of fact, he couldn't buy the regular ones. So in order to access the market, he actually had to infringe. Nonetheless, an apportionment was carried out because the invention, even in those circumstances, couldn't be considered to be attributable to all the profits. So yes, we do submit that because it's used as a tool of isolating the value, the objective value of the invention, then you don't have to show. I think Mr. Cuddigan called, I think the Lordship has adopted subjective evidence. What would in practice have happened.
Sorry?
I'm coming to that later. Yes. So, in the end, we say it's not the be-all and end-all. Like many counterfactual methods of analysis, as the majority of the Supreme Court pointed out in MBS, in the passage cited by my Lord Justice Arnold in Neo, this counterfactual is prone to give rise to overcomplexity and confusion. So it's not the universal panacea that perhaps it's been portrayed as by some of the academics. The reference to MBS is Authorities, Volume 3, Tab 64, at 23 to 25. And we could perhaps pull that out. My learned friend's right to point out we're looking there at a particular form of counterfactual of the type which was used by, proposed by Lord Hoffman in Samco to deal with advice or information cases where the advice or information turned out to be negligently false. So that's. But if one looks at what Lord Hodge and Lord Sales say at 23 to 26, we would submit many of those difficulties, and in particular at 26, many of those difficulties also apply in patent cases if one tried to use them as a matter of course. They talk about the danger of manipulation in argument of the parameters of the counterfactual world. Lord Leggett points out, and there's no doubt Lord Leggett is very keen on counterfactuals, both in this case and in the Cadzee, both of which is in the minority, that the counterfactual test can yield the right result if it's properly applied, but the more one moves from the comparatively straightforward type of situation, such as Samco, the greater scope there may be for abstruse and highly debatable arguments about how the counterfactual world should be conceived. So shouldn't allow the counterfactual analysis to drive the outcome in a case. And they go on, risk of litigation, a way of contest between elaborately constructed worlds, increasingly untethered from reality. And without going into all the details, between D and E, Lord Leggett engaged in a sophisticated analysis to answer the elaborate variants of the submissions advanced by the parties. The fact is that a distinguished constitution of the Court of Appeal fell into error because of them. The better approach is to focus more directly on the purpose for which the defendant gave the advice in question. No need to apply counterfactual tests to correct confusion, etc. And we would adopt, again I'll come to it in context, the adoption of that, those passages by my Lord Justice Arnold in Neo. We note the symmetry between the reference there to considering the purpose of what the court's trying to do with what my Lord Justice Lewison said in Abbott about the importance of having the purpose of the underlying right in mind when considering the remedy. Some of the events which were played out in the present case illustrate the difficulties of the NIA approach. And the arguments made by Lufthansa by way of appeal also tend, as I shall show, I hope, to also tend to prove that it is not a panacea. I've already shown you some of the Canadian authorities. As your lordships are aware, the Supreme Court in Canada has said that the nearest non-infringing alternative approach there is the preferred approach to apportioning profits. And my learned friends quote Dow on that at paragraph 24 of their skeleton. I mean, first of all, that is not the law in the UK. No court has gone that far or even close to it. Indeed, as I say, no such apportionment by reference the nearest NAA has ever been carried out in the UK. But it is clear, and I think I've already looked at some of this, that the Canadian courts consider that the NIA is simply a tool for answering the real question underlying an account, which is the same question I identified earlier, and I submit Lord Justice Lewison was adverting to in Abbott, namely to uncover the profit attributable to the inventive contribution of the patentee, namely the subject matter for which the patent monopoly was granted. I think I've shown you already those relevant passages in Dow, tab 90 at paragraphs 51 to 53, 60 and 67. And it's explicit in those passages that the aim of the account, whether it's using a non-infringing alternative or not, is to isolate the profitability of the inventive concept as opposed to the other elements making up the defendant's infringing product.
You use the phrase the profit attributable to the use of the invention. The statutory instruction is the profit derived from
Yes.
the infringement. Is there any difference between the two?
I think at least in one case, I've forgotten now where it is in the authority. Gerber in the Court of Appeal, or Justice.
Sorry, which one?
I think Lord Justice Staunton in the Court of Appeal in Gerber suggested that the word derived might have some significance in indicating a narrower field of inquiry than merely caused by. I don't think anybody has particularly followed that up with any analysis. We submit that the authorities are by now pretty clear and well established as to what one's looking for, but the word is not particularly precise and leaves it open for judicial interpretation. I don't think we place much reliance on the semantics of the word itself. Yeah. Yes, sorry, that's right. So that's for your note, that's Authorities 1, tab 30, page 613, at lines 14 to 22.
That was a case about damages, so
yeah.
Questions of profits were not the courts.
No, I think they were just being discussed in general argument. Yes. Yes, the important point that I haven't yet made in relation to the Canadian authorities is one that we'll come back to. But what is, we submit, it's clear in Canada, both in terms of the authorities and academic writing, that if a defendant there seeks to argue that profit should be apportioned and raises an NIA or an alleged NIA, but it's then rejected on the basis that the NIA is infringing, so-called NIA is infringing, the court can still apportion value in the what's called the pre-Schmeiser, the old-fashioned United Kingdom authority way. And there are two things I want to show you on that. First, in Dow, Nova and Dow itself, the dissenting judgment, but on this point, so far as I can see, there's no reason to believe that she's doing any more than stating established law. Mrs. Justice Cote makes this explicit. And you'll find that in Nova and Dow, that's tab 90 at paragraph 213. And it's the bottom of the bottom of 3048. She refers to the infringer making an implausible argument, but can't establish it. The differential profit approach can't be used. In these circumstances, the court may properly conclude, and then she says in brackets, after determining that no further apportionment is necessary, that it is appropriate to apply either the full costs approach or the differential costs approach. This is entirely consistent with the concept that it's the preferred means of calculating the account of profits.
How does that work? If the best non-infringing option fails, how can you apply a differential costs approach? Which is what she seems to be.
Yes. So you put forward your non-infringing alternative.
Yeah.
It is found actually it's still infringed, so you haven't got a non-infringing alternative. So the court then can say, well, I haven't got this tool to work out the value of the invention, but I can nonetheless apply other tools to get to the result of.
Well, I understand that that's the bit about in the brackets, but
yes.
She goes on to say it is appropriate to apply either the full costs approach or the differential costs approach, and that's the bit I don't understand. If the differential cost has been ruled out on the facts, which seems to be the situation that she's contemplating.
I think this is the technical term, differential costs approach.
I see, differential costs rather than differential profit.
Yes, right. Which and I didn't want to go into.
All right, never mind. I've set a hair running unnecessarily. No,
I think those are two ways of getting profits, depending on the basis of what sort of costs you're allowed to look at.
Yeah.
Which we don't need to go into, I hope. But a rather. On the facts of Dow, it's right to say that the trial judge, having rejected the non-infringement, did award all the profits, and Lufthansa placed a lot of weight on that fact from Dow. But if one looks carefully at what was found in Dow, one can see that it didn't appear simply to have followed as a matter of course. The trial judge didn't simply look at the non-infringing alternative. He also found on the facts that the invention was the entire essence of the product, and customers only bought it because it contained the features of the patent. And one can see that, sorry, I'll put it away now, I shouldn't have done, tab 90, paragraph 69 of this Justice Rowe. So two facts are referred to here. One is Justice Rowe. The second one, in paragraph 70, is the rejection of the non-infringing alternative. The first one, in paragraph 69, importantly, is the passage I think we looked at already. Customers only purchase them because they contain the features. In other words, in our language, it drove the sale and it constituted the essence. The invention constituted the essence of the product. So, having found that, then the judge was justified on the basis of those two findings in not needing to go any further and awarding all the profits. That I would submit is entirely consistent with traditional. Okay.
Could my lord read the whole of that sentence? Paragraph 69, the whole of the first sentence in growth. So the second sentence.
And if my lords have still got that bundle out, we then get to my own friend's favourite author, Mr. Seabrasser, which is on tab 92, sorry, 3160. Well, starting at 3159, dealing with apportionment, noting the goal of the counter profits quickly lead to difficult questions, profits spring from the use of complementary assets, traditional solution, apportionment of the infringement, and that's one of the most difficult questions of the pre-Schweizer. Differential profits extremely helpful in dealing with this problem. Apportionment generally unnecessary. Plaintiffs entitled the difference between those which have been known as the most likely infringing alternative, exception of precise test. The plaintiff is entitled only to the value or profits causally attributed to the infringement. Using a but-for test, put another way, a value-based apportionment is embedded in the differential profits approach. But then he goes on, once this is recognised as apparent that many of the pre-Schweizer actual profits approach cases can be reconciled with differential profits. So by pre-Schweizer actual profits, he's talking about the UK style apportionment, not using non-infringing alternatives. Apportionment efforts and pre-Schweizer approach can often be seen as reasonable attempts to implement a value-based apportionment without the benefit of an expressly value-based test. As in differential profits, also, if the defendant fails to prove the most likely alternative, the differential profits approach will resolve to an inquiry of the actual profits approach, making the issue of apportionment relevant even under the differential profits approach. So he's saying explicitly, if the differential profits fails, the defendant fails to prove the alternative, or in parenthesis, prove that it didn't infringe, you go back to Schweizer and allocating profits in that way. Just to fill that gap, one can see when he talks about actual profits, as he says at the beginning of 5.0, that is indeed a case of apportionment, and he makes that also clear in paragraph 2.2, paragraph 2. So we submit that in Canada, it's not a game, the rules of which are you, the defendant, have to make your case based on an uninfringing alternative, and if you fail to show it, you've got to hand over all the profits of your business. The court is still asking the same question and may have to find another route to get to the answer. Because after all, as this is made very clear in both Dow and this article, the whole point of NIA is to get to the same answer as the pre-Schmeiser approach. It's not a different approach in law. The extent to which this analysis of differential profits is in dispute may be narrow between the parties. My learned friends seem to agree that differential profits are in fact a type of apportionment. See paragraph 3 of their reply skeleton and the quotation from Professor Cotter, paragraph 17. And I think my learned friend made the same concession, same statement yesterday. And he didn't suggest, and indeed I think he may even have positively accepted, that other methods of apportionment which have been used in other cases are not any longer admissible for some reason, or are in some way secondary to the non-infringing alternative approach. Turning to the job of the judge in the present case, we submit that there were essentially two critical questions. First, whether this was a case in which the overall profits on the product, which was the subject of the claim, should be apportioned to reflect the relative causative powers of the invention and other factors, and second, how to go about that apportionment on the facts. And in answering the first question, the judge had to consider what causes there were of the profits alongside the infringement, if any. And to do that, as my Lord Justice Lewison said in Abbott, he first of all had to identify the invention, which, as we've seen, is a single safety feature in the power supply unit, implemented within a bit of the power supply unit called the ISPS. It had to get the power using cables to the seat, had to provide a socket, but the invention was the socket shouldn't go live until both pins had been detected. We've seen how that was done on the PPD and judgment. The commercial context was, as you've seen, that this unit was either supplied for direct power purposes, Astronics for installation in seats, or incorporated in an in-flight entertainment unit and supplied for installation in seats by Panasonic. The Panasonic sales are in fact the bulk of the profits claimed in this case. And when one comes to look at the context of the making of the profits, one of the things that the judge emphasised, and it's hardly surprising, was that the attraction of the in-flight entertainment system within which the power unit, within which the safety feature which is the subject of the invention was installed, was based on a wide range of things, not including safety devices. What people were interested in was the quality of the entertainment system. So one has a kind of expanding universe from this single safety device through the power unit into the actual component which people were buying, which the airlines were buying, which by this stage had in-flight entertainment and all the features that business class travellers want to see in the back of the seat rest in front of them or on the screen that now pops up. It's probably worth giving you a summary. The judge does it, but if I can assist in pointing you towards the findings that he relies on, it might help. On the question of the causative effect of a multiplicity of factors in the present case on the ability of Astronics and Panasonic to sell the units either as direct power in-seat sockets or as an integrated part of an IFE. And just take you first of all to the judgment. See, the judge goes through this at 467. And these summarise his findings, having seen a mountain of evidence about the technical and commercial factors which go into the success of these products. He kicks off by referring to the barrier point. I'm sorry, 467, page 261 of the confidential appeal bundle. And this is where he is weighing the need for the use of the invention to get certification or approval of the airframe manufacturers against the other factors that were relevant to the generation of the profits in issue. And he gives his conclusion in that initial paragraph, and then gives a series of reasons. And the first of these is that although Astronics used the insertion and timing features, that's two of the three features of the claim, in order to satisfy the mating condition in the 1999 memorandum, that condition was not introduced to ensure or require compliance with either the insertion test or the patent. So, in other words, it's a freestanding requirement. It's not that the memorandum itself was written off the back of the invention. Moreover, and perhaps more importantly, he says the
But
mating.
Mr. Cullen's point is you couldn't have satisfied that condition without infringement. I mean, he says that that because of the patent, they had if you like, a stranglehold on entry into the market.
Yes.
And that's it. That's the be all and end all.
Yes. So the airframe manufacturers, on the judge's findings, having seen the KID product which utilised this insertion safety feature, required at least 2 of the 3 features of the claims, depending on whether it's Airbus or Boeing, to be used in order to be satisfied that the product was compliant. But the rule itself is a general rule and not specific to the invention. I think that's the only point the judge is making. I think it's relatively minor. He goes on to say that it was only one of 24 conditions that GD had to satisfy to obtain certification of the mPOWER systems. And he says this particular safety feature, that's the one which the patent enables compliance with, required a lower degree of assurance than the hardware features of those systems. In other words, it was regarded as less critical, if you like, in terms of proof than the hardware features. And if I can just give you a reference to that, one can see that's in paragraph 369 and 374.
309.
369 and
369.
374 of the judgment. So 369 is the reference to Mr. Jupiter. You may have seen that already.
Yes.
And then the fact that the court shouldn't lose sight of other hurdles. So it was one factor. 374. This is a reference to the judge. This is the judge making various findings on the evidence concerning I think that's what's paragraph 3.3. Probably doesn't matter. The implementation of the plug-in detection device involved 2 software features and therefore required a lower degree of assurance than hardware features. Mr. Repenning accepted this, and when I come to evaluate the positive versus the fact that bear in mind it wasn't a safety feature which required the highest degree of assurance. So it may have been a requirement, but not the highest degree of significance so far as safety is concerned. The second point in 467 is the reference to Boeing. So separate approvals were obtained here from Airbus and Boeing, being what's referred to as the airframe manufacturers, as opposed to the actual customers who were buying the product. And the judge says, although Astronics used all 3 inventive features of Claim 1 to obtain Boeing approval, and the insertion and timing features to obtain Airbus approval, so just in parenthesis, the judge has found there are three elements to the inventive concept, which he calls insertion, timing, and remoteness. And of those three elements, in fact, Airbus only required to be satisfied in relation to two of them. They weren't bothered about remoteness. Boeing wanted all three. But in the case of Boeing, these included 36 additional safety tests unconnected with the features of Claim 1. In the case of Airbus, the relevant requirement was not a safety critical feature, and one which significantly reduced aircraft safety. And Astronics had to satisfy 7 major safety critical requirements and 1 other minor requirement in order to obtain approval. So, just stepping back, looking at Airbus, for example, the judge had seen a raft of evidence, cross-examination about all this, and what had become clear was that the certification requirement that was being relied on was not considered to be a safety critical feature, or one that significantly reduced aircraft safety. Astronics, however, had to satisfy 7 major safety critical requirements and 1 other minor requirement in order to obtain approval. So there was far more to achieving safety than this single feature, which had been, as it were, considered to be the implementation of the regulations. One can see that in paragraphs, as far as Airbus is concerned, 385 and 386. As you'll see in 385, Mr. Duper didn't accept that the TS0011 required Astronics to satisfy the remoteness test, which was one of the features of the claim, and Mr. Cunningham didn't pursue that point with him. And Mr. Brady gave unchallenged evidence that the spec strongly recommended the manufacturer should design safety critical features or functions in hardware. And the requirement that Malone and friends relying on, TS011, both pins being inserted at the same time, fully engaged, was characterised as a minor D safety feature, which would not significantly reduce airplane safety. Mr. Brady also referred to the table, which identified 7 major safety safety features and 1 other minor D safety feature. So this is not regarded as massively critical to safety by the airlines, whereas a load of features clearly were, and therefore required Astronics to satisfy all of them. Going back to 367, we can move on to
467.
I'm sorry, 467.
Read 467, Mr. Purvis?
Yes, 467. I do apologise. Some other purpose at 467. His third point is he accepts that the insertion and remoteness features, which he's held to be the inventive core, were necessary for GD and then Astronics to obtain certification approval, but they were not sufficient. This we'll come back to when we look at NEO, necessary, not sufficient. Each mPower fusion system had to satisfy the other safety requirements and the detailed technical specifications before they could obtain certification. It was the ability to satisfy all the requirements that was the real driver, close analogy with Neo, which we'll look at when we look at the second ground of appeal. Fourth finding, this is about the power-only sales that represented a fraction of the market and a fraction of the claim to profits in this case, but they were a distinct element of the commercial trade. And what the judge is finding is here that the AC power function was functionally and commercially essential to Astronics power-only sales. Now that is not particularly surprising, that the power-only sales required the AC power function. But as he says, he also finds that the power management functions of the system, which we've looked at in the PPD, were equally essential to commercial exploitation. So
By power function, I take it he means the inventive concept of the patent. Or does he mean something else?
No, I think one has to be a little careful, because the AC power function is just the ability to provide AC power.
Oh, I see.
The safety feature is part of what it is that supplies the AC power, but of course it's only one part, as the judge has found. So he is, as it were, fanning out from the invention through to the power functionality and saying the power functionality as a whole was critical. And then he's saying, but wasn't the only essential feature. Astronics needed both functions in order to make the direct and power only sales an issue. That is to say, they needed the AC power, for which included the safety feature, which was essentially invention, but they also needed the power management that they had designed and was very highly regarded function, and they wouldn't have made the sales without them, and that the power management functions drove the sales just as much as the infringement of the patent. So there is co-responsibility, if you like, between AC power functionality and power management functions, even with just the direct power sale. Fifth, he makes his findings about the IFE, which my learned friend objects to his reference to the percentages. Now, true, Astronics generated its revenue, 78% of its revenue from IFE sales worldwide, and Astronics was only being sued in this case in respect, I think with a few exceptions, but in respect of power-only supplies. But the critical point here is that the bulk of the profits which were being claimed in this case came from the supply of the ISPS, or the mPower system, for incorporation in an IFE, which was then installed as part of the ship set on the aircraft. So the IFE was absolutely critical to achieving the sales which are being relied on to support the claim to profits in this case. So what's important about this paragraph is not the details of the percentages, but the findings that the judge makes about the relevance of the AC power outlets to personal entertainment devices. He says they weren't commercially essential to those sales. The most significant feature of the IFE systems was the quality and variety of the entertainment experience the system provided. Insertion and remoteness features were not commercially essential in the sense used by his Honour Judge Haycroft.
But I thought that Mr. Callaghan's point was that the infringements and profits relied on were those generated by infringements within the UK, and they did not include sales to IFEs.
They're not relying on, yes, it's correct to say they're not relying on the profits made on the sale of an IFE, but what they are relying on is the profits on the Empower Fusion Systems Incorporated and supplied with IFEs by Panasonic. That is the claim against Panasonic.
Right.
Well, Astronics were making the Empower Fusion. The claim for this chunk of profits, which is the bulk of the profits in the case, is against Panasonic purely because Panasonic were incorporating what they bought from Astronics into the IFE. So the circumstances in which the IFEs were being bought and the motivation to buy the IFEs were generating the profits. People hadn't been buying these IFEs off Panasonic to install in their planes. These sales by Astronics would never have been made. And that's therefore why the IFEs were so important and why such a lot of time was spent at trial looking at them. And what the judge is saying is, in that context, what purchasers are interested in is not some minor safety feature of the power supply that happens to be an add-on, as it were, to the IFE. They're buying it for the fact that you've got Paramount Plus or so many pixels on your screen.
Yeah.
Stereo sound, whatever it is. That's the point. And it's notable, the judge makes those findings at 426 to 431, and I won't take you to all of that. But it's notable that even Lufthansa, when they were putting out a matrix of requirements for what the IFEs should have, did not include the provision of AC power. And one can see that at 429 and so 429, the defendants relied on Virgin Atlantic's compliance matrix and an example of one of Lufthansa's. Virgin Atlantic contained approximately 260 requirements, only one referred to AC power. Lufthansa had 450, it didn't refer to 110 volt AC power or any of the features of the patent. And then there's a long reference to the evidence, and the judge makes his findings at 430, and then again at 439. So this is quite striking in terms of the significance of this invention as part of the overall causative factors. And then 6 is an important point, or rather raises a matter of very significant importance. First of all, the judge notes that the market was duopoly But Astronics had a massive dominance in the market compared with Kidd. And of course, the bulk of the sales were IFE. And he finds that Astronics achieved the dominance because of its superior product, and in particular the weight of the SPM. And he goes on, I've also found, and this is important, that Kidd's failure to find a satisfactory solution to the heat dissipation issue with the Kidd SPM and the failure of the Lufthansa project effectively shut it out of the market. In my judgment, these factors, not the infringement of the patent, drove the sales in the integrated market during the relevant period. And the evidence on that starts at 419 and goes through to 424. 419 is about the superior product and the superior service of Astronics. And then 421 to 424 details the huge problems which Kidd, who were the exclusive licensees of Lufthansa to exploit the invention, had when they were trying to compete for the supply of SPMs to Panasonic for the Airbus and the Boeing aircraft. And the point was that Kidd were in pole position with Panasonic. Panasonic wanted to buy from Kidd. And Kidd had huge problems technically making their product because of what was called the heat dissipation issue. And they tried numerous times to fix it and failed. The judge found at 421 towards the end became, from Panasonic's perspective, the integration of Kidd became a nightmare project involving an unusually large number of Panasonic personnel. Kidd failed to supply documents, test data in a timely fashion. Don't accept the evidence of Mr. Moselbach and Muirhead, attempted to play down its significance. But I find as a fact, the failure of the project and Kidd's failure to find a satisfactory technical solution to thermal dissipation, significant commercial setbacks, and effectively shut Kidd out of the market. So a significant reliance on email correspondence. And then in 424, the fact that Kidd, following Kidd's replacement by Astronics on Lufthansa project, Kidd obtained no contracts for the supply of the SPM to either Panasonic or Thales, who were the people pulling them in the IFEs, with two very limited exceptions. In 425, he's rejected the case that was being put forward on the other side, that this was in fact all to do with an Airbus policy. So the relevance of that, and my own friend tries to say, oh, well, that's not relevant at all, but it's highly relevant, we submit, because this invention clearly did not open up the market, even for the exclusive licensee. It was utterly unable, even given the ability to supply Panasonic, to do so because of the technical problems associated with developing the product, in particular heat dissipation. So when my learned friend tries to downgrade the contributions of the defendants, and Astronics in particular, it's against the background that no one else could get this to work for the key integrated product. And there were obviously huge contributions being made in terms of the technical as well as the quality of product, the technical ability to get the thing to work, which were hugely causative of the profits which Astronics ultimately made. And that was a factor we submit that the judge was well entitled to take into account when looking at the multiplicity of causes.
Can I just explore this with you a little bit? A lot of Mr. Cuddigan's submissions strike me as adopting, if you like, a linear approach to causation. There are a series of hurdles, one after the other, and you've got to jump over them all. The metaphor of chain of causation is also, of course, a linear metaphor. You, I think, are saying this is not a linear question. There are causes, so to speak, coming in from all around the globe, or around the clock, if you like. And the task of the judge is to evaluate their relative causal potency.
Yes.
In the same way that you might do in a completely different situation if you're looking at, I don't know, contributory negligence,
Yes.
or contribution, or one of those things. So that's...
Well, that is exactly a point. It's a point I was going to come to when we come to NEO, because I think it was particularly in that context we noted that point being made, that, and we don't recognise the distinction between, as it were, a temporal chain of events and a multiplicity of causes that could come in either later or at the same time as the invention. I think that probably the 7, 8 and 9 kind of tie these points together. 7 makes the point that the reasons why the products and services were superior were unrelated to the exploitation of the patent, and the reason why Lufthansa failed and Kidd couldn't find a solution to heat dissipation was unrelated to mental features, etc. But we've seen those points made already. The 8 is the rejection of the Airbus policy point. And 9 is a sort of legal conclusion that he says Lufthansa, towards the end, Lufthansa and its team got into the trap of treating the question of whether there was an NIA as determinative of the overall issue of legal causation. I think I've dealt with what he said about that. And so he then holds what he does at 468 about what drives the sales, what doesn't, multiplicity of causes, and so on. So as a result of all, it was as a result of all those factual findings that the judge considered it was appropriate to apportion the profits in this case between the invention and other contributions, and he did so, and we'll come back to this, by reference to the test in NEO, which was advanced by both parties as being relevant, although it is, of course, a damages case, but it has some resonance to the present case because it deals with a lost profits claim, albeit it's the claimant's lost profits as a matter of damages, and it deals with the multiplicity of causation issue in that context. But I'll come back, if I may, to NEO when we look at the criticisms made by the other side of what the judge says about it. But what he's doing, using the language of NEO and indeed the language of my lord in Abbott, is identifying what the real drivers of the sales were, testing the argument for payment of all the profits by that test, and holding as a fact that the infringement was not the real driver of any of the sales that led to the profits in this case, which is at 4673 of the judgment. The judge then, of course, had to decide on the appropriate methodology for apportionment, having rejected the NIA, and as we know, he explained at 570 that the decision on how to apportion and what technique to use was law. At 571 to 573, he explains why the licensing approach taken in Jack Wills and Cipriani may be useful in the present case. And then between 474 and 475, he looks at 4 ways in which
574, I think.
I'm sorry, 575. I beg your pardon. 574 and 575. He looks at 4 ways in which the defendants had suggested that had pleaded that apportionment could be carried out. And as he noted in 576 to 577, Lufthansa had studiously avoided putting any positive case forward. And that was a considered position. We'll come back to some of this, I think, in relation to the 4th ground of appeal. But see also, in this respect, what he says about Mr. Ryan's evidence at 583 and 590. And just by way of summary, the judge ends up selecting, by way of a percentage, a number derived from the evidence which he had about what KID were paying for the use of the invention, and they were paying fixed sums per unit. That fixed sum was then applied to Astronics' net profits on the item for which the license was granted. Now, Mr. Bezant would obviously have preferred to calculate that percentage based on KID's profits, because then you start with a number and you get the percentage that the actual parties agreed between themselves. But that information was not made available, so he had to take Astronics' profits as a proxy for what one might expect KID to have been expecting to make on essentially the same products. And the end result produced a fixed amount by way of profits, 4.4 million Astronics and 7.4 for Panasonic, which amounted to some 21% of net profits if you deducted a share of general overheads, which on the law you can do if those overheads would have been used for another non-infringing product, that's Dart and Decor, or 13% if not. And since the non-infringing alternative was, there wasn't a non-infringing alternative, then it turned out to be the 13% number. That's, in a very short, very small nutshell, how he got to the figures, and we'll come to the criticisms that are made of that in due course. Can I now turn to what we say about the grounds of appeal? Now, the first ground of appeal is essentially this, that once the judge had rejected the non-infringing alternative, which was being relied on by the defendants as in fact infringing, the judge was effectively obliged to award all the profits made by the infringing product to Lufthansa. That's you can go on this to my friend's skeleton argument at paragraphs 24 to 25. As a summary of the proposition. And he sets out, Lewison set out in paragraph 24, a three-step procedure provided by the majority endow for an account of profits in patent infringement. First, calculate the actual profits, revenue minus for differential costs. 2, determine whether there's a non-infringing option. 3, if there is a non-infringing option, subtract the profits the infringer could have made had it used the non-infringing option from his actual profits to determine the amount to be disgorged. And then in 25, they simply say, I quarrel with the judge as he added a fourth step, conduct Celanese apportionment on the outcome of the differential profits analysis. There's no justification for so doing. Its objective has already been achieved at steps 2 to 3. Our answer to that you will already be aware of, having followed my submissions earlier. The first point is Mr. Justice Rowe was not considering the question, what happens if the NIA, which is put forward at trial by the defendant, turns out in fact to infringe or not to be available for other reasons. Nova and Dow in the majority does not provide the answer to that question. I've already shown
your argument, I think, is step 1, calculate the actual profits earned by selling the infringing product. Right, well, the judge has done that.
Yeah.
Step 2, determine whether there is a non-infringing option that can help. The judge has said, no, there isn't. End of steps. Step 3 is conditional on finding
that there is
such a problem.
Yes. And what isn't said is, well, what happens if the defendant has picked the wrong thing and it turns out it does infringe? Am I, as a judge, obliged to throw my hands in the air and say, well, I can't do anything now? Or do I look at the overall facts of the case and do an apportionment on a different basis? That's the point, and that's why I showed you Mrs. Justice Cote, who appears to think that yes, you can do that, and Professor Seabrasser, who positively avers that that is exactly what you would do if the defendant fails on its non-infringing alternative. You apply the pre-Schmeiser approach, that is to say, the traditional approach taken in the United Kingdom to apportionment of profits. So that's what we say, and we say that there's no obvious reason, as a matter of logic, not to do that, because what my learned friend agrees or avers is that the purpose of looking at a non-infringing alternative, if one can find one, or if the defendant has identified one, is the same objective, has the same objective as the other methods of apportionment. That is to say, to get at, as a tool for getting at the question, what proportion of the profits are attributable to the inventive step. And if it isn't available, well, let's say the defendant hasn't advanced it at all, why can't the court, when considering that issue, not look at alternative ways of doing it, which are better and clearer on the facts of the case?
Well, I think his answer on differential profits is that there is a non-infringing option. Don't sell the product.
Yes. We say that's it doesn't make any sense. I mean, there is always a non-infringing alternative, which is don't sell the product, but that's not actually an alternative. It's doing nothing. And I mean, one could apply that to just about any of the intellectual property cases, that one can always just do nothing. But that would result in just about any case of the claimant apparently picking up all the profits. What's going on here is the defendant is saying, well, we know there are multiple causes here of the success of the product. Let's try and get at the question of what proportion of the profits should we attribute to the invention. A tool for doing that is an alternative product that doesn't use the invention. So puts that forward. Unfortunately, it turns out that the one that was pleaded did use the invention. That's not to say there aren't other possibilities, but they're not in the case, or they weren't being relied on.
At one level, there's nothing between you because it's agreed that these are alternative approaches. Your submission is that the UK case law shows that the apportionment approach is preferred. Use of an NIA is not excluded, but in practice it's never been done. Mr. Cuddigan's submission is that the differential profits approach is preferred, and he relies on the Canadian authorities in support of that, but he accepts that it's not the only approach.
Yes,
he accepts that in some circumstances it can be appropriate to do apportionment. Where you really differ, it seems to me at the moment, is in the second stage of Mr. Cuddigan's analysis, which is he says that you can't do both.
Yes.
And as I understand it, your submission in answer to that is that's not what the judge did.
No, he didn't do both. He just did the alternative one because the first one didn't work. So it's not a double deduction because the first exercise just resulted in nil return, and the second exercise resulted in an appropriate apportionment, which is in accordance with traditional UK law. I think Justice Arnold summarises it, the difference between us accurately. We had thought at some stages in this appeal that the real objection is a kind of procedural one, that as a defendant you have to kind of elect between approaches. And if you elect to go down the non-infringing alternative route and you put one forward and you're wrong on construction, as we were in this case, it turned out that we had the construction wrong and it did still infringe, then procedurally we're just shut out from relying on anything else. Now, we don't understand what the basis for that would be as a procedural objection. All these points were pleaded. All these points were there on the evidence for the judge to look at. And there is no authority that some kind of election has to be made as a defendant between one approach and another.
Well, I understand that's an issue. I think the submission made is actually slightly different, which is to the effect that you prove their case for them. Because the submission is made is, well, you tried to prove an error,
yeah,
you failed, and therefore you proved that this was a gateway patent.
Yes.
That's the argument.
Yes. And our answer to that is the fact that it's a gateway patent does not mean that you scoop the whole profits for a number of reasons. that we submit would be a massive windfall to claimants, which would not properly reflect the parallel causes of the success of a product, the real input and contribution of the defendants, which the traditional approaches do allow to be recovered. And it would, in fact, in terms of accounts of profits, introduce a policy that necessary was enough and you didn't have to prove sufficient. So the neo reasoning, which we summarise as the use of the invention was established to be necessary, but it wasn't sufficient to make the infringing sales, and therefore causal link was not established, would not be being applied in profits, because you're essentially saying the mere fact that as a matter of regulatory requirement, for example, you needed to use this invention to have a product that you could sell, means that you've got to hand over all the profits regardless. Whatever the technical limitations of the invention compared with the vast inputs that went into the product may be. And we say that that is just manifestly unfair and would give rise to plain case of unjust enrichment. It also gives rise to a number of obvious practical problems where, for example, there are 2 or 3 or more barrier patents. When one thinks, for example, of standards, whether in mobile telephony or other electronic cases, or any case at all, whereby to access a particular market one has to satisfy certain features, and it turns out that some of those features are protected by
That's why the FRAND regime was introduced.
2, 3 or 4. So there is a FRAND regime. It doesn't apply to everyone. It varies depending on the nature of the standard system that one's looking at. You don't automatically have a license if you're not signed up to the system. So the question would be, why would it be, well, certainly on a friend's case, anyone who owned even one of those patents would, as against a party which did not have a license, be able to claim all the profits on the complex product, just because of one of the patents that had to be used. The same would apply to 10, 15, 100 other people who also had patents. And no one would think that that was a reasonable result. Clearly, these patents are causative of the feature in question. The mere fact that it is necessary to use them to access the market does not mean that it is right as a matter of equity that the patentee scoops all the profits on the entirety of the complex product. We submit that that would be a remarkable and inequitable result. But yes, I think at the end of the day, that must be my learned friend's final position, that merely establishing the fact that you needed to have this feature to get your product into the market means that you scoop all the profits, including on elements to which you had made no contribution at all, including profits made by the presence of features which you had never thought of. including profits made by the sale to customers who you hadn't opened the market to by the invention, because as demonstrated by the fact that your exclusive licensee couldn't even manufacture a usable product. So all of those we submit are matters the judge looked at rightly when considering multiplicity of causes, and elevating effectively a regulatory requirement into a higher level type of cause that always trumps everything else is, we submit, unfair and unjustified. It's worth the NEO case is a just comparison, because on the findings of fact in that case, NEO were found to have had to use the invention in order to be able to access the market on the balance of probabilities, as recorded in Lord Justice Arnold's judgment. And the claimant argued in that case explicitly that having proved that, the necessity of using the invention, and having a finding of factual causation, that was enough. You should get all the lost sales profits by way of damages. And the court said, both below and my Lord Justice Arnold accepted it, said, no, that's not enough. It's not enough to have necessity established. You need to go beyond that and look properly at all the surrounding causes that went into the ultimate sale of the property. So it's not a trump card to have a regulatory requirement that has to be satisfied that immediately nets you any profits that the defendant may have made.
So I don't want to jump ahead to ground two, but to what extent is your answer in the profits context one of legal causation, and to what extent is it of a different answer? Your submission is factual causation not enough, and again, there's no difference between you and Mr. Cuddigan to that extent.
Yes.
He accepts that factual causation is not enough.
Yeah.
Accepts that legal causation is relevant.
Yeah.
His submission is it only comes in terms of shortening the chain of causation.
Yes. I'm going to come to that on NEO shortly, maybe very soon. We say it is a matter of legal causation looked at broadly, although I don't think the courts have ever, as I say, in the counter profits case, divided up causation in that strict manner before. But these questions, Your Lordship in NEO definitely found were matters of legal causation, and we say it's appropriate to think of them in the same way for profits. And that gives the court a broad remit to determine whether the use of the invention is, and we would say, a sufficiently proximate cause of all the profits that you can exclude the other features.
Well, that's the hanging question, isn't it? You say legal causation. Causation of what? Causation of all profits, some profits?
Yes.
Any profits?
Well, that's what the court is doing by engaging in an apportionment. It is attempting to value the causal potency as a matter of law, bearing in mind questions of remoteness.
It's not really a question of remoteness, is it? Because remoteness is, well, you
Yes,
can see that A cause B and B cause C, the chain of causation. But some of those things are just too far removed from the wrongful act.
yes, yes,
And that's Mr. Culligan's point. You can understand legal causation in that sense. Remoteness. You're using legal causation in a rather different sense, which is almost there are multiple causes
yes,
of the profit. You wouldn't have made any profit at all if you hadn't infringed, because it's a gate name.
sure,
But you said, well, but we wouldn't have made any profit if we hadn't produced something which the airlines wanted, which in terms of all the other features it had. So the profit, there's only one lot of profit at each sale. It only generates
yes,
one lot of profit.
yes,
But there are multiple causes
Yeah.
of that. And you say, well, there are multiple causes that you have to identify.
yes. Your Lordship's quite right, and I shouldn't call that remoteness. I think it's legal policy, perhaps, as established in all the cases we've been looking at, that when one's looking at what can be recovered for the infringement of an intellectual property right, one doesn't scoop the pool. One does consider all the other causes which are playing on the fact and ultimately causing the profit to be made.
So does it come to this? In your submission, apportionment is, in appropriate cases, a proper tool for trying to determine what profits are legally caused by the infringing act. Factual causation having been established.
Yes, yes. Legally caused for the purpose of this particular statutory wrong and this particular remedy.
And that exercise, you say, involves evaluating the respective causal potency of all effective causes.
Yes,
The language used by the Supreme Court of Canada in the Bear case is isolating the profits causally attributable. Now that obviously doesn't mean factually causally attributable, because we know all the profits are factually causally attributable to the
Yes.
infringing act. So that must mean which, as a matter of law, are treated as causally attributable to the infringing act, as opposed to the profits attributable to non-inventive features.
yes,
It's in that sense that it's legal causation. It's not quite.
but
Attributing it is just, in an appropriate case, apportionment in your submission.
yes, and it's not a matter of mathematical exactness, as they say in some of the authorities, but it is
Well, it's
the
even,
court's attempt.
you couldn't even theoretically, I mean, in the My Kind of Town case, you could theoretically interview every single customer and say, why did you go to the restaurant? If you've got a complete answer, you could produce a mathematically precise analysis.
Yes,
But you couldn't even theoretically do that here, because if you ask your purchasers, why did you buy this system? You're not going to have a whole lot of different answers. You're going to have, well, we bought the system because it has all these things,
yes,
including it produces AC power, and that was something that our business class customers really wanted.
yes,
I don't know what you're told. You couldn't have done that without infringing.
yes. It is a sui generis situation, the account of profits, which is why perhaps it's generated its own body of law. The purpose of it, we submit, is reasonably clear in that it seeks to avoid windfall, unjust enrichment, or effective
Well,
punishment of
I
a
think
defendant.
Mr. Cuddigan, I mean, these are emotive words, windfall
Yeah.
and unjust. I think Mr. Cuddigan says there's nothing unjust about it at all. The patent gives us a monopoly, as it so happens. This particular market, we had a monopoly on this market, and you went and played in my field without asking me, so I'm entitled to say that was my market, I'm entitled to all your profits. I think
Yes,
he effectively said that.
yes. But in
I don't
reality,
think
yes.
describing it as a windfall or unjust is an answer to the question, because that's just a characterisation,
Yes.
whether we like the answer or not.
Well, it's perhaps underlies some of the policy that what has in fact happened here is that it's the defendant's contribution, which on the judge's finding here has opened up the market, enabled the market to be exploited, and therefore the profits don't, as a matter of common sense, we can put it that way, just derive from the use of the
Absolutely
invention.
necessary but not sufficient.
That's necessary but not sufficient.
Turns out it was necessary to infringe the patent. You say the judge found it wasn't sufficient to generate these profits.
Yes, yes, and that's why we say Neo was actually very important. I mean, both parties urged Neo on the judge, but if one seeks to draw a principle from Neo, that is it, necessary. Is
And the
not
differential profits
sufficient
approach
on its
in a
own.
way reflects that principle, because all the other contributions to the success of the product are on both sides of the comparison.
Sorry, my lord, I just missed the last few words.
They're on all the other effective causes of the profit, apart from the patent, the invention,
Yes.
are on both sides of the comparison.
If one does the
so the
comparison.
infringer gets the credit, so to speak, on both sides of the comparison for all the effective contributions that he has made to the product.
Right. If one is engaged, if one has the perfect.
Oh, of course, if you can do a differential
Situation.
profit analysis at all.
Yes, it can work.
So in the present case, if the 1171M had turned out to be non-infringing as you contended,
Yes.
then that would have been a suitable comparison for differential profits, because on that basis most of the other factors would have been held constant.
Yes, and that's what people like Professor Seabrasser say. It's theoretically can be a very good tool for getting to that isolation. But if it doesn't work, it produces a nil return because it turns out it's not actually a non-infringing alternative at all. Then, as Professor Seabrasser says, what can you do? You have to go back and look at some more traditional approach to profit attribution. Yes. Can I turn then, we've probably had quite a lot of the Neo discussion, but to look at the second ground of appeal, and it might be useful to have Neo open at tab 60. Sorry, authority 69. 69. So,
Which bundle?
sorry, my lord, it's bundle 3.
3?
Tab 69.
Yeah.
And learned friend pointed out rightly some loose language in my skeleton argument, for which I apologise, but the thrust of our submissions aren't affected by it. What was going on here was infringement by the supply of this infringing cerium oxide, which is a chemical added to automotive catalysts to enhance performance. And in order to get approval so that it could land a contract to supply Johnson Matthey, who was a mutual customer of both Rhodia and Neo, who were CEO producers. That Neo supplied cerium oxide into the UK, thus infringing the UK patent, for the purpose of testing and evaluation. And the question arose about losses by way of damages claimed by Rhodia, the patentee, as a result of lost sales. The lost sales took place abroad. They said that they would have been providing the cerium oxide had it not been for the original act of infringement, whereby Neo wrongly got or illegally got approval from Johnson Matthey so that their cerium oxide could be used in the catalytic converters supplied to car companies. So it all stemmed from the original act taking place in the UK, but as a matter of fact, we say it's not particularly relevant, but as a matter of fact, the ultimate supplies by either party, first the patentee, the notional supplies for which it was claiming damages, the lost sales, and the supply by Neo, which was taking those lost sales, would have taken place abroad, and therefore wouldn't have troubled the courts as a matter of, as far as Neo was concerned, as a matter of infringing acts. So that was the background to it, and the question was whether those lost sales, which Rhodia said it had suffered, lost sales abroad as a result of the original act of infringement in the UK, were recoverable by way of damages. And the key findings, which aren't in doubt, are first of all that the judge found that there was factual causation between the original infringement and the claimed lost sales. So they were sales which Rhodia would have made but for the act of infringement in the United Kingdom. And secondly, as my Lord Justice Arnold noted, that it had been necessary for Neo to infringe in order to get the business. So the necessary finding is at 116. The judge found that it was, although the lost sales were actually caused, as we've seen, by the original act of infringement, they were not legally caused for reasons set out by my Lord Justice Arnold from paragraph 109. And you'll see the submission that was being made on appeal. Rodeo were contending that the three factors identified in 193 do not, whether individual or community, justify her conclusion the infringing action were not a proximate cause, because the judge failed to take into account the infringing nature of the product. And he takes them in reverse order. Factor 3, they were both qualified as suppliers. Factor 2, the orders were not placed with or subject to the same contract as the orders of infringing suppliers. And factor 1, there were multiple intervening contingencies. Rodeo say there was really only one contingency, which was whether Neo's product satisfied JM's requirements. That depended solely on mainly whether the product infringed the patent. At worst, there was a second one, which was whether JM's catalyst system satisfied the car maker's requirements, but again, it depended solely on mainly on whether Neo's product infringed. And this was rejected by my Lord Justice Arnold in 110. Noting it was a cumulative effect of all these various factors that led the judge to conclude the infringing suppliers were not a proximate cause. Didn't say that any would have been decisive on its own. And then he deals with factors 3 and 2. But if we skip over to 113, most important factor is factor 1. Fair to say the judges raised multiple intervening, which is something of an overstatement. But in context, clear what she meant. The judge explained Neo's sales depended not only on JM's decision as to whose serum oxide purchase, but also on the car maker's decisions as to what catalyst system to purchase. So this is another case with some resonance to the present, where the sales depend on having an overall product which is attractive to customers. Here, if you like,
That's the sales by JM to the car makers.
Yeah, yes.
But what Neo were doing was supplying
The CEO.
a single chemical to JM for
Yeah.
incorporation in a system which they would then sell to the.
But what pulled those sales in was whether the ultimate car manufacturer wanted the overall product that JM was supplying.
Yeah.
If it did, then great. Neo would have supplied some CEO to enable product to be produced. If not, then
Yeah.
not.
Well, Mr. Purvis, shall we leave it there for
Yes.
today? How
Thank
are
you
we
very
doing
much.
for time? I'm aware that you didn't get started till 11:45 this morning, so
Yes.
the Lufthansa team have used up quite a lot of their allotted time, if I can put it that way.
Yes, and I don't want to use too much of mine, but these are important matters. But I'm
Yes,
very
but
much
we've
getting
still
towards the
got
end of my
another
notes. We've
three appeals to go. So
I know, I'm very aware of that. I think I'll be able to skip through, in the light of the discussions that we've had,
Right.
our responses on the grounds of appeal relatively shortly
all
tomorrow.
right, fine. But Mr. Cuddinger, I just remind you, you are being held to 2 days. 10:30 tomorrow.
Right,